So you have state statutes, at least that were after the federal statute, that pretty much mirror how the federal statute was laid out. But as you go along with when you're creating law, when you have people tinkering, coming in, and sometimes for the positive, sometimes for the negative, and sometimes just different. So you'll see that in many of the statutes, and I gave you a sampling, if you have that handout, gave you a sampling of state statutes. In some of them, the language is mandatory. The healthcare provider, the genetic counselor, shall hand over specific information. That means it's mandatory. That means you have to do it. You're required by law to do it. And in some statutes, it is permissive. They may. And so it basically becomes an awareness, a possible way to get the state information developed, but it doesn't create a mandate. And then you have a statute like in Texas. I included that in the back, which is it says shall, and then it later says this is not going to create a duty. So it's just confusing. And then in some states, it might say termination is not recognized. It should not be recognized as an option in state recommended materials. And they might have language that say it shouldn't mention termination directly or indirectly. And that's important to know, because if there is a mandate that you have to hand out state materials, and then there's a provision that termination not be mentioned in those state materials, indirectly or directly, it means that you should be looking at your materials, and if you have other obligations to make sure certain information is shared, then you need to tap into another resource. So, or at least make sure your conversation is covering that. So it's important to note those things. Then in some of the statutes, they are print materials, so the state would make available print materials for medical providers to hand out versus purely an online delivery system, such as in Pennsylvania. Then there might be simple fact sheets versus established materials that create that meet the criteria, like in Massachusetts. So you might have some very specific criteria of what the state materials have, and then the provided materials by the health department of that state are very specific, very detailed, versus just a printout.
Well, I'll kind of just explain a little bit on that note. So, for example, Ohio created a state fact sheet. We made an NSGC template that states could use and modify if they wanted to create their own fact sheets. Because the problem was that it was kind of getting assigned to sometimes just a bureaucrat at the public health office, and they didn't really know necessarily or have background with Down syndrome. So we thought, well, we'll make this available to them so that they have a template that they can use that's been reviewed by the medical organization, also been reviewed by advocacy. So Ohio has a variation of that template, but like in Massachusetts, they actually have a stockpile of the letter case books. You can request them and you can get them from Department of Public Health. Washington State has done the same.
Yeah, and it really gets into why it's important when you're practicing in a particular state or when you're treating someone who lives in a particular state, that you make sure you know what the statute in that state exactly says and what the state materials are in that state. Yeah, and I think that the intention from the beginning was to rectify some of the variation where some people were having positive experiences, some people were having negative experiences, and kind of bring it up to at least a minimum level to know, well, at least everybody's getting information. And that was the goal behind the movement originally for the federal statute. And certainly that was the goal as the state statutes started to come into play. That's what people wanted. But as things moved along, and that's what we're going to talk about that a little bit, as things moved along, particularly from state to state, there was a sort of patient-based movement for I'm receiving medical care, I want to receive information, to somewhat more politicized process. And it wound up kind of making some of those state statutes go from uniform state statutes to specific changes in an individual state where they put in the materials cannot mention termination either implicitly or explicitly as a choice. So the movement itself was this pro-information movement starting on, but whenever you have groups of people, you have people with different ideology, and the process, especially if you're dealing with 50 states, the process can get changed in any one individual state, which is why these statutes do vary, part of the reason why they vary. So, and this is important because when we see that there are state statutes that you are required to hand this out. Sometimes as a medical provider, your first reaction might be alarming. You know, wait, I'm required to say this to my patient. I'm required to do this to my patient. I'm prohibited from doing this. And just take a step back, because for right now, none of the state acts prescribe that patients receive only positive information. And I know sometimes when there's newspaper articles, they might be the statutes might be couched that way. And my answer as someone who teaches legal analysis is, well, let's look at the actual statute and see what it says. So none of them say that the patients should receive only positive information. None of them direct what you can or cannot say to a patient. None of them requires you to recite a script. And more importantly, none of them restricts you from handing out additional materials. So if you do not like the state materials that the state is mandating you hand out, you have to hand them out, but then you can supplement with whatever you see fit as a medical provider that are appropriate materials. If you have a mandatory state statute that says a healthcare practitioner that administers or causes to be administered a test for Down syndrome to an expectant or new parent shall, upon receiving a test result that is positive for Down syndrome, provide the expectant or new parent with educational information made available to the department under Section 4. So if you have, that's from Pennsylvania. So if you have a mandate that says you have to hand it over, what happens if you don't? And we don't really know. So everything we've listed here, you'll notice, has a question mark at the end of it, because it's not really clear what the consequences are to not handing it over. I mean, speaking as an attorney, I would say just hand it over. You don't want to roll the dice. But some of the possibilities might be civil complaints, criminal penalties, whether we think this is far-fetched. I mean, some of them are far-fetched. Ethics board, state licensure penalties, complaints with hospital patient ombudsmans, mandatory distribution of non-existent materials. Oh, that's a separate question. So these first four things are possibilities maybe that might happen if you don't hand it over. Now in New Jersey, there's a mandate to hand materials over, but there are no materials. They don't have them up. What happens then? Well, I don't see how they could possibly enforce anything if those materials don't exist, but it certainly would give you reason to say, well, maybe I should make sure I hand out some good materials. And I'm not aware at this point of any enforcement at all. On the next slide, the other laws to consider. So if you have, you're delivering a prenatal diagnosis and you have a mandate to hand over information, or even a suggestion to hand over information, that's not the only thing you as a medical provider have to worry about. Certainly you have other things, whether they are professional ethical requirements that are specifically written down, wrongful birth claims which exist, wrongful life claims which exist in some states. So, sometimes you have to put different pieces of a puzzle, kind of a myriad of things together to say, okay, what are my total obligations all the way along? Do I have to make sure I hand this out? I have to make sure I say this. I have to make sure I'm doing it all, walking that fine line and making somebody have not necessarily a positive experience, but not make it worse by what I'm saying, and with the potential to make the delivery of information better than it may be if it was delivered by someone else. Statutes that are being passed in some of the states, which are prohibiting termination for Down syndrome, and I'm not sure of the variation on those statutes, but I believe some of them provide penalties for medical providers. But whether that means negative implications for people having discussions, you'd have to read the specific state statute. I don't have those, but whether that stands constitutional scrutiny, I mean, it's such a quicksand area, but I think it's just making sure you're aware of what's going on in your individual state. And that means the state where you're practicing and the state also where your patient is.